Keep Our Republic is a nonpartisan, nonprofit organization. Since the spring of 2020, we've been doing our part to help keep our republic. We do it through hyper-localized civic education. We talk with Americans through town halls, legal seminars, media briefings, and other events. We know a lot of Americans have a lot of questions right now about how our democracy really works. Questions like, what actually happens behind the scenes on election night, and just what is the power of the federal courts? That's why we're talking directly to election officials and judges from across the country. Together, we can help answer some of those questions. Welcome back, everyone, to Keepers of Our Republic. This is a weekly podcast from the nonpartisan nonprofit Keep Our Republic. As always, we're talking in depth with judges and election officials from around the country who are speaking up in support of our democratic institutions and the rule of law. Today, I am very happy to be joined by former federal Judge John Tinder. We'll be chatting about some of the threats and challenges facing our federal judiciary and the legal system at large right now, and why it is something that all of us, not just judges and lawyers, need to be paying attention to. So with that, welcome, Judge, and thanks so much for joining us today.
Great. Glad to be here. Nice to meet you, Brooke.
Nice to meet you as well. A little bit of background and bio for myself and, of course, for our listeners. You graduated from Indiana University School of Law and were an assistant U.S. attorney for the Southern District of Indiana from 74 to 77 before you entered private practice and later returned to being a prosecutor. I believe you also dabbled a little bit as a public defender, and you were the chief trial deputy for the Marion County Prosecutor's Office, all before being nominated to the District Court for the Southern District of Indiana by President Reagan. You served for 20 years as a judge and was nominated by President George Bush to replace a vacancy on the Seventh Circuit, and we retired in 2015. Did I get that all right?
Yes, there was one little stop I made before I became a district judge, and that was I served as United States Attorney in the Southern District of Indiana for about 3.5 years before I became a district judge.
Right, right.
Also nominated by President Reagan for that job.
Thank you. Let's start there then, because I'm going to hazard a guess based on your bio. You are a lawyer that loved trial work. Is that right?
Yes, and that's what I thought I would do all my life. I never expected to be a judge. I thought I'd be a litigator. And, pardon my dog barking in the
Oh,
background, but
don't worry. I got dogs over here too. You're fine.
I had the federal experience in working with folks in the Department of Justice in USA and then as U.S. Attorney. And to me, this is how litigation was to be done, and it's what I thought I would do for the rest of my career.
So what was it bittersweet then leaving that behind and going onto the bench, or just sweet, I think many people would feel?
It was a little bittersweet. In fact, I made a few comments that if I could get a job for life, being U.S. Attorney would be the one I'd want to have. It's a very important and influential position. You determine policy for law enforcement in the area in which you work to a very large degree. And one of the most important things that a U.S. attorney can do, most powerful things, is to say no. No, we won't prosecute that, or no, there's not enough evidence, or no, our policies are not focused on that. So it was a job that I very much enjoyed, and I loved the professionalism of the folks who were on my staff, most career prosecutors. And also within the Department of Justice, the very experienced people in all of the areas, civil rights,
Yeah.
fraud, tax, you name it. They really were the best of the best, and it was a great experience.
And it's something that has been on my mind, and I know in the news recently this week. For reference, we're recording this on January 15th of 2026, and some news broke recently about a number of AUSAs in Minnesota who offered their resignations in protest, I think it's fair to say, after um, uh, in response to investigations into the ICE shooting in Minnesota last week or within the last 2 weeks. I just kind of want to speak to I know we're mostly focused on the judiciary here at Keep Our Republic, but as you pointed out, the prosecuting branch, particularly DOJ, AUSAs, are so bound up with our federal judiciary and the justice system and public perception of the justice system. I was kind of wondering if you could speak to this moment of what we're seeing with these mass resignations of attorneys starting to pop up in the news cycle.
Yeah, I would say that this recent set of resignations in Minnesota is sort of an exclamation point on what has been happening in the last year. I think the statistics bear this out that a very high percentage of senior Department of Justice people have resigned or retired, who are eligible for retirement. Some of the very most experienced and long-serving individuals. Um, and some of the areas that are really vitally dependent on that kind of experience, I think, are feeling the effect of that. You're having a short staffing at top levels, and you're having a real you're seeing a real diminishment of the experience, and that's a very negative thing. U.S. attorneys, Department of Justice lawyers are probably the most frequent litigants, the most frequent lawyers who appear in federal courts, and courts rely on their experience and rely on their regularity and sort of the normal way of doing business. And to have this affected is, I think, is a very difficult thing for courts to face. Who do they
Yeah.
rely on when a case is brought? Whose word can they depend on? This notion of prosecution without fear or favor and doing the right thing. That was one of the things that I always enjoyed about being an
Mhm.
AUSA and then later as U.S. attorney, and enjoyed the collegiality of others throughout the country. Of we all felt we were doing the right thing, and that when push came to shove, we could make the hard decisions. And many of those hard decisions were saying, no, we're not going to do this. This is not right. And it was a feeling of great responsibility to have that discretion. And never in the 6 or so years that I was associated with the Department of Justice did I ever feel the outside influence that I'm hearing about and reading about today, where the executive announces who's to be prosecuted and why and so forth. That's just stunning to me. Stunning.
What risks are we coming up against from a broader like democracy perspective if we're entering a world where prosecutors, federal prosecutors in particular, are no longer able to say no or to yeah.
Well, yeah. The weight of a federal investigation or prosecution is tremendous. And when once an individual or their family or company is subject to that, it is a terrific drain on the resources. And if it can be done just at the whim of the executive without things working through the regular process, the regular investigative process, where the outcome is announced before the investigation has begun, it just turns the whole system on its ear. And the confidence that people have in that system will be deeply eroded. In order to have whistleblowers, in order to have cooperative witnesses within these complex investigations, it's very important that people have confidence in that investigative system. And where the results are announced before the investigation takes place, who can have confidence in that?
Yeah.
It's hard to measure it in statistics, but just the sense of fairness and justice is deeply eroded.
Yeah. Another topic that we've seen kind of come up recently, you mentioned this idea that verdicts or prosecutions or in the results of investigations are being sort of announced before the investigation has even had a chance to commence. We're also seeing a lot of concern, fairly or unfairly, of people thinking that, judges' decisions are sort of a judge has already decided a case before they've even heard the case. How fair do you think that is? both historically, or is this a new phenomenon we're seeing with this further politicization of the judiciary?
Well, I suppose since judging began, some people have been skeptical of why judges make certain decisions or whether they'll be fair and so on. But what's happened with the internet's both the most wonderful thing and the most horrible thing that could ever happen. Uh, Information travels at such a speed, even before the ink is dry on a judge's ruling around the world, these speculations have passed as though they're very authoritative about why the judge made that decision, who influenced it, and so forth.
Yeah.
And the judge has no means of responding to that. The judge just does the judge's work, and the work stands on its own on what the reasons are, what facts are considered, and so on. The judge doesn't have a PR spinner to get out there and start, uh, you know, sending things out to blogs and so on. And the folks who want to ridicule or give false attribution for reasons to this can move much more quickly than the facts themselves. It's
Yeah.
very unfortunate, very
Yeah.
unfortunate.
And it's sort of the catch 22 of our legal system, you could say our government writ large, is that it was designed to move slowly with the thought that that would prevent abuses of the systems. But it, that slowness when it comes up against instant information, 24/7 news cycle has created such a unique set of problems.
Yeah, I hate to hear it described as slow. It's not intended to be slow, but it does move
Yeah.
at a pace where things can be sorted out. Your first impression of something is not always the right one, and both sides deserve to be heard, and the facts need to play out and weighed and considered carefully. Um, it was a system designed to have that sort of weighing and evaluation and independence of the trier of fact. And to trivialize it as though these things are already decided the moment they're initiated is it's a bad treatment of it, frankly. And I think that's inspired a number of us who have been through those trenches and seen how things are really done to take our free time
Yeah.
and devote ourselves to things like this Article 3 coalition to speak out on behalf of the courts that can't speak other than through their rulings and the regular work that they do, and to bring some reality into the evaluation of what's being done in the courts. So I'm sorry, go ahead.
Oh no, I was going to ask what has been um, sort of most important for you to speak out about once you left the bench? What was like really on your heart that you were able to finally speak freely about?
Well, one of the statements I made as I was retiring as well, I'll get my First Amendment rights back, which I'd had in the closet for
Not
28
unfair.
years.
Yeah.
So, but initially I didn't really have much to say. But as I've in recent days watched these depictions of what should happen and how it should happen and why it happened and why a judge made a particular decision being trivialized, it's made me feel strong about wanting to speak out and wanting to get those First Amendment rights out and let people know. Uh, Courts are designed to work in deliberate ways, and judges make decisions based on what's in front of them, what the law is. They're not creating the law. They're not uh, uh, imagining what the facts are. Facts have to be proven. And judges work very carefully and very deliberately to try to get to the right result. And jurors absolutely do the very same thing.
Hmm.
Was always very impressed with how serious jurors took their jobs. Here they are, people from every walk of life thrown into the room together to do something they've never, that compares with nothing else they've done in their lives. and they are all eyes and ears. They put their 12 minds together, and they work very hard to try to work to come to the right result. And it doesn't matter who the president is or who initiated the charging decision or who presents the defense. They really try to do the right thing, and I think we need to continue to remind ourselves because there are these forces trying to trivialize it and make it look like a rigged system, and it's not. It's simply
Yeah.
not.
What do you think are some of the biggest misconceptions the public has about how the judicial process, the process of fact finding or making a ruling? What misconceptions do you think are just so pervasive we need to deal with them?
Well, I think people who have served on juries and who followed cases closely from the inside have a good appreciation for it. But I think to listen to or to read some of conspiracy theory,
Yeah,
crazy stuff that's going around there, that you would think that the first thing the judge does when he or she gets the case is they wonder, well, how would the president who appointed me want me to decide this?
yeah,
Absolutely not. That would never enter the mind of a judge, either at the trial or the appellate level. Who cares who the president is at the present time, or was when you came on the bench, or it was in between? It has nothing to do with how the decision is made or why it's made. That's, I think, the number one misconception that's being touted by these self-made experts on the judicial system.
yeah. And it's so interesting. In the last couple of years, it's just you can't escape, Judge Smith appointed by. It's like it's part of your name. John Tinder, a
Of
Bush
course,
appointee, of course. Like it's
right,
like they got
right,
added onto your name. They've become so synonymous, and I think that's such a miss
right.
on the part of the media, but our own like public discourse about how the legal system works that has just further eroded this idea that we have an independent third branch.
Yeah, I think I learned a lot about that on a personal level when I went from the trial court to the Court of Appeals.
Mm,
Um, so in the Seventh Circuit, we had judges appointed by a variety of presidents, both Democrat and Republican. And uh, we did not go into camps. I'm in the Reagan camp, you're in the Clinton camp, and so on. Absolutely not. It was an amazing intellectual and collegial experience to reason through things with those who came from different ideological backgrounds or different political backgrounds or what have you. And it really renewed my faith in the independence of the judiciary and the judicial decision-making process. So, on a
yeah,
personal level, that meant a lot to me. And I think if people who are spinning all of these theories would carefully look at the history of the judiciary, who was involved in various decisions, and how the decisions played out, I think they would not feel comfortable spinning these theories that the appointing president determines the outcome of the case.
yeah. I had one of your colleagues on at the beginning of the year, Judge Wood, who was also on the
Yes.
Seventh Circuit. Were you on the bench at the
Yes.
same time as each
Yes.
other?
Yes. Yes, we did. And she was the chief judge for a good
Tremendous.
portion of
Yeah.
my time. Yes.
She was a
Well,
tremendous guest and tremendous jurist. And
what a
she,
mind, what a wonderful mind
oh,
she has,
incredible.
and
Yeah.
very, very easy to work, easy to disagree with, which is
Yeah.
kind of I hope she takes as a
No,
compliment.
I think she would take that as
Uh,
a compliment.
and really was a good person to have those kinds of back and forths with,
Yeah.
that it takes to get to the right decision that considers all views. And at some point, you may have to agree to disagree, but you do it
Yeah.
on a very reasoned basis. You don't do it on any sort of preconceived notion.
Yeah.
Yeah, having people of her skills is a tremendous thing within the court system, and we have. the United States judiciary, the federal judiciary, is the crown jewel of our democracy. I would host visitors from other countries in judicial areas, and I visited a number of other countries related to various judicial matters. And the first thing that any emerging nation attempts to do is to develop a judiciary modeled on ours,
Hmm.
and it is just renowned for its fairness, for its independence, and for its reasoning, and we need to talk more about that.
Yeah. Well, I usually we're talking such heavy topics and I have to end on kind of a downer note, but you have given us for once a really upbeat, positive note to end on. And one can hope that by having these conversations, we will continue to be a model. Our judiciary will continue to be a model that courts around the world strive to emulate.
And
Yeah.
I think it will. I think
Yeah.
we are seeing judges weathering the storm. They are continuing to do their job. They're continuing to try to be careful in the opinions that they issue, and for their. I've read about the anonymous pizza delivery
Hmm.
things, and the
Yeah.
digital doxing where people's home addresses are put out and so on and so forth. This is not something that judges can protect themselves against very readily. We've had terrific security from the Marshal Service and so forth, but they can't stop everything. And judges need to uh, work in an independent environment and in one where they feel confident and comfortable. And shame on those that do anything to interfere with that. So,
You're here. Well, Judge, I don't want to take up too much of your time. Thank you so
all
much
right,
for joining us. It has been just an absolute pleasure. I look forward to having our paths cross again and have you back on. And thank you for joining us.
sounds good. Nice to meet you.
If you like this episode, please share it on social media and tell your friends. It's the best way for folks to find out about us. I hope you'll agree that our guest is indeed a keeper of the Republic. If you want to learn more about how you can help keep our Republic, stop on over to our website, keepourrepublic.org.